A treatise. Ox the law of deeds, their form, requisites, execution, acknowledgement, registration, construction and effect. The alienation of title to real property by volume. UNTARY transfer. TOGETHKE with chaptikks on tax deeds and sheriff's deeds. By HOBEKTT. DEVLI. Counselor at Law. 2nd edition revised and enlarged. In 3 volumes. Volume 1. San Francisco. Bancroft Whitney County 408 Montgomery Street. 1897. Copyright, 1887. By Robert T. Devlin. Copyright, 1897. By Robert T. Devlin. Preface to 2nd edition. The lapse of 10 years since this treatise was written has rendered a new edition necessary. During that time one have examined the cases that have been decided since the first edition went to press, and have made such use of them as seemed best adapted to this edition. Some of them are simply affirmations of well-established principles of law, and their citation would serve no other purpose than as cumulative authorities to lists already too numerous. Others involve only questions of fact. Others still are based upon special statutes, but many which state no new principle of law yet show its application to some novel condition of affairs, or make clear some rule on which courts have not agreed. Many new sections have been added to the text, others have been rewritten or enlarged, and ample additions have been made to the notes. I have at all times kept in mind the fact that a work intended for a practicing lawyer should contain many different features, and I have in the insertion of new matter folio verses add the same general outlines described in the original preface as the plan of this treatise. The enormous number of new cases considered has necessitated the extension of the work to 3 volumes. Special attention has been given to those topics that relate particularly to the form, execution, acknowledge. 067896. PIV face. Ement, delivery, nil registration of deeds, description of property conveyed, and kindred subjects relating to deeds, considered as instruments intended to convey title to land. Still, their effect as executed contracts has been exhaustively considered. Every chapter has been revised and enlarged, and the new matter inserted has been thoroughly indexed. It has been my aim to make this treatise a practical exposition of the law of real property and to treat fully all subjects relating to the transfer of title to land by the deed or voluntary act of the parties. The favor with which the original edition was received, while it demonstrated the necessity for a work on the subject treated, has been gratifying to me in showing that these volumes in a measure supplied the want. I gratefully appreciate the consideration which this work has met, and hope that the 2nd edition will be as favorably received. Robert T. Devlin, Sacramento, Cab, Feb. 1, 1897. Preface to 1st edition. From the earliest times, the law of the alienation of real property by voluntary transfer has formed, in every count R, an important branch of jurisprudence. At the present day TLIE mode of alienation has been much simplified, but, universally, a deed is required for the conveyance of real estate. In works on real property the subject of deeds is only incidentally considered, such works being necessarily general in their character. Sir Edward Sugden, in England, and others in our own country, have rendered the profession valuable aid be TLIE preparation of treatises devoted to the contract of sale, the law of vendor and purchaser. I have taken up for consideration the deed itself, by which the title in fee is conveyed. Only in an incidental way have I adverted to the law of vendor and purchaser. A glance at the table of cases will show how frequently questions relating to deeds have come before the courts, and it is believed that a treatise devoted exclusively to this subject will be gladly welcomed by the profession, although some of its parts are considered in other books. It was not my original intention to treat of anything but the law governing the voluntary alienation of real property. I concluded, however, that the value of the treatise would be enhanced by the addition of chapters on tax deeds and deeds of sheriffs and constables, and have added chapters treating of these subjects, so far as they can be said to be a part of the law of deeds. I believe that a law book, to be adapted to practical use, ought to be written with several different objects in view. IV preface. It ought, in the first place, to be a treatise, in the strict sense of the word, in which legal principles are announced and explained. Vlir a divergence of opinion prevails among different courts, the outlier ought to endeavor to find the fundamental principle by which they may be harmonized, or failing in that, ought to state what, after a careful examination of the divergent authorities, he considers to be the correct rule. If he has done his work faithfully, his view, writing as he does from an impartial standpoint, should not be altogether valueless. The work should state, also, what the courts have decided. 4. However illogical the conclusion reached by a particular court may be, the rule announced has the force of law in the slate in which the decision is pronounced. There can seldom be, in actual practice, much dispute over well-settled propositions. The difficulty which besets a court in the decision of a controversy, or a practitioner in giving counsel, is the application of a principle to a state of facts. Hence, a textbook should not only state bare legal propositions, but should illustrate them with instances in which they have been applied. Then, again, the multiplicity of reports, and the difficulty, save in large cities, of gaining access to them all, should induce an author to lay before his reader, whenever the importance of the principle under discussion is sufficient to warrant it, that part of the language of the court pertinent to the point considered, not only as an aid to the busy lawyer, but also as a means by which the writer's conclusions may be verified. On this plan, I have written this treatise. I have endeavored to state legal principles, to illustrate them with apt cases, and finally, in proper instances, to furnish the reader witly the words in which the courts have declared the law. While endeavoring to lay before the reader the law, as decided by the courts, I have frequently, in attempting to discover the correct rule, commented upon conflicting decisions. But such matter has generally been. Preface. Verses placed in a section by itself, so that my own views and conclusions may not be taken as giving the effect of the decisions of the courts. In cases of contrariety of decision I have endeavored to state correctly both views, in order that if my own opinion may not be acceptable, the authorities sustaining an opposite view may be consulted. An author has considerable difficulty in determining how far his researches should go in the multiplication of authorities. I have sought to state fully the leading principles of the law of deeds, with their exceptions and qualifications, and have supported them with an abundance of authority. Many cases I have purposely omitted, and some, undoubtedly, have escaped my observation. Perhaps I have erred, in some instances, in citing in support of generally accepted propositions more cases than necessity would require. But as the book is intended for use in every part of the United States, it seemed able that it should contain a collection of cases from the different states. If the number be large, many of them will at least serve the purpose of illustrating, in various ways, the principles in support of which they are cited. Though no formal division has been made, the work consists of 10 parts. Part first, embracing chapters 1 to 6, is devoted to a consideration of the general requisites of deeds, including, with an introductory chapter, such matters as the various kinds of conveyances, what must pass by deed, the parties to a deed, the necessity of a writing for the conveyance of real estate, and the doctrine of part performance. Part second, consisting of chapter 7, is taken up with a consideration of the formal parts of the deed, treating of such matters as the form of the deed generally, the date, the name and description of the parties, the granting words, the habendum, redendum, and testimonium clauses. The execution of the deed constitutes part third, consisting of chapters 8 to 13, in which part attention is given to the reading, signature, seal, and attestation of the deed, and its delivery, either absolutely or in escrow. In part 4, the preface, consisting of chapters 14 to 18, the question of the execution of deeds in certain relations is considered, taking up the subject of execution of deeds by private and municipal corporations, execution of deeds under powers of attorney, under powers of sale in trust deeds and mortgages, execution of deeds by trustees for sale, and lastly, the subject of alterations and filling up blanks. Having now an executed deed, Part 50, including chapters 19 to 22, is devoted to a treatment of the law of acknowledgement and registration, and the notice supplied by the record. This concludes the first volume. Part 6, consisting of chapter 23, contains a statement of the law of notice, in general, by possession, agency, and liandens. Part 7, chapter 24, treats of the subject of the consideration, and the various rules connected with it. In Part 8, the construction of deeds is considered. This part, consisting of chapters 25 to 30, includes the general principles of construction. The law of community J-Roperty is applicable to deeds, the law of covenants, conditions, limitations, reservations, exceptions, restrictions, stipulations, recitals, and description, and of a deed subject to a mortgage. Part 9, including chapters 31 to 37, treats of the effect of deeds, or of the transactions resulting in deeds, embracing such matters as, whether a deed absolute in form is a mortgage or not, the effect of a deed where the grantee does not pay the purchase money, the effect of the deed in conveying fixtures, the vendor's lien, and the effect of the deed by way of estoppel and merger. This concludes the subject of voluntary transfer, and the 10th part, consisting of chapters 38 and 39, is devoted to a consideration of deeds made under authority of law, tax deeds, and sheriff's deeds. Requiring years for its preparation, and covering a wide field, the work must have many imperfections, and I shall be very happy to receive any suggestions of inaccuracies or omissions that may be observed. If it shall, preface, v. do not toward giving a clearer conception of TLIE law on the important subject of transferring title to real estate, yet in the hope that it may assist both bench and bar by its arrangement and citation of authorities, and by showing where the law may be found, it is submitted to the profession. Robert T. Devlin, Sacramento, April, 1387. Contents. Chapter I. Introductory Chapter. Section 1. Introductory. Section 2. Historical View. Section 3. Statute of Lieutenants. Section 4. Statute of Frauds. Chapter 2. Definitions and different kinds of deeds. Section 5. What is a deed? Definitions. Section 6. Agreement for a deed. Section 7. Same continued. Section 8. Illustrations. Section 9. Classification of deeds at common law. Section 10. Theftement. Section 11. Gift. Section 12. Grant. Section 13. Iveis. Section 14. Excliange. Section IR greater than. Partition. Section High Release. Section 17. Confirmation. Section is void deeds. Section 19. Surrender. Section 20. Assignment. Section 21. Defeasance. Section 22. Deeds under statute of uses. Section 23. Bargain and sale deeds. Section 24. Covenant to stand cease to uses. Section 25. Ease and release. Section 25. Fine and recovery. Section 27. Quitclaim deeds. Table of contents. Chapter 3. What must pass by deed, or by writing. 28. General comments. 29. Equitable interests in land. 30. Part A. SBIP to buy contracts for sale of land. 31. Compensation for wrongfully obtaining patent. 32. Rule a carrot to mining claims. 33. Statutory regulation. 34. Right to carry away or. 35. Right to dower and interest in land. 36. Pews. 37. Fixtures. 38. Possession as an interest concerning land. 39. Stokely incorporations. 40. Interest of execution purchaser. 41. Contract for board and lodging. 42. Equity of redemption. 43. Improvements upon land. 44. Qualification or enlargement of interests already acquired. 45. Revival of void contract. 46. Revival of satisfied mortgage. 47. Agreement for execution of covenant to convey. 48. Executory agreement for creation of lease. 49. Lands owned in partnership. 50. Peril proof of partnership in land. 51. Same subject, rule in various states. 52. Agreements to establish title to land. 53. Release of damages affecting land. 54. Agreements to devise interests in land. 55. Application of rules relative to specific performance. 56. Peril evidence. 57. Growing crops. 58. Occupancy of the land. 59. Distinction between fructus industrialis and prima vestura. 60. This distinction in New York. 61. Other carrot states. 62. Opposite view, where this distinction is not observed. 63. Easements or interests in land. Chapter IV. The parties to a deed. Part 1. Who mat convey by deed. 64. Legal capacity to convey. General comments. 65. Capacity to take or transfer real estate governed by the law. Res cité. Table of contents. 11. Section Goes apperment for benefit of creditors. Section 67. Disability of insanity. Section 68. Weakness of mind. Section 69. Evidence on issue of mental unsoundness. Section 70. Nervous excitement. Section 71. Deed of person deaf and dumb. Section 72. Insane Huselwind joining in wife's deed. Section 73. Deed, when voidable. Section 74. Deed, when void. Section 75. Deed, by whom may be avoided. Section 76. Restoration of consideration. Section 77. Ratification of deed. Section 78. Effect of grantor's subsequent insanity on contract of cure. Chase. Section 79. Disability from intoxication. Section 80. Degree of intoxication. Section 81. Deeds made under duress. Section 82. Threat of legal proceedings. Section 83. Grantor's will power. Section 84. Deeds made under undue influence. Section 85. Disability of infancy. Section 86. Deed of minor voidable only. Section 87. Right of DLS aliments. Section SS. Whether affirmance of infant's deed may be presumed from acquiescence. Section 89. Same subject. Section 90. Opposite view that acquiescence is not affirmance. Section 91. Comments. Section 92. By what means the deed of an infant may be avoided. Section 93. Subsequent deedle must be inconsistent with prior one. Section 94. Restoring the consideration. General rule. Section 95. Exception in Indiana. Section 96. Where minor has not retained consideration. Section 07. What is a sufficient ratification of an infant's deed? Section 98.